I'm Dennis Sullivan. Today I want to talk about prenuptial or premarital agreements and if there are ways to attack them or have them declared unenforceable in Texas. In Texas, prenuptial agreements are valid, and if they are signed by both parties, they are presumed to be enforceable. As a result, if you are a party to a prenuptial agreement and both spouses have signed that agreement, you have a high burden to prove that the agreement should not be enforced. There are only two ways to block the enforcement of a prenuptial agreement. The first is if the spouses did not sign the agreement voluntarily. The second is if the agreement was unconscionable and before signing the agreement, the spouse was not provided with a fair and reasonable disclosure of the property or financial obligations of the other spouse, did not voluntarily waive the right to such a disclosure, and did not have, nor reasonably could have, adequate knowledge of the property and financial obligations of the spouse. So that's it. That is all that will cause a prenuptial agreement in Texas to be unenforceable. The requirement that the agreement be voluntarily entered into does not mean the trade-off that the marriage will not take place unless it is signed. It means, did you do so out of your own free will? If there were no misrepresentations, if the parties were represented by attorneys, or if the spouses were lucid or not being forced into signing the agreement is likely to be found to have been voluntarily entered into. The second way to block the enforcement of the agreement is if the agreement is unconscionable. Unconscionable means something that is extremely unfair. The facts of such an agreement would be that there is such a great difference in the spouse's ages or maturity level or educational level or in their mental acuity or in the dynamics of the relationship that indicates one spouse is able to draft the agreement in such a way that no reasonable person would consider the agreement to have been entered into at arm's length. However, there is a second half to this requirement, and that is that the parties did not disclose all of their finances, that the spouse who is attacking the agreements did not know of the state of the finances of the other spouse, nor reasonably could have known. The lawyers at Stepp Sullivan are here to help you with any prenuptial or other family legal issues you have. We are more than happy to meet with you in person, but can also meet with you through Zoom or Skype or simply over the telephone. If we can answer any questions you have, or if you need any additional information, we're here for you. We work one-on-one with our clients to focus on the outcome that is most important to you. At Stepp Sullivan, we make it personal, powerful,